All right, the court will find you guilty. The court will sentence you to 14 months in the state jail facility. Give you credit for any time served. This will run concurrent with 719-615, 719-616. Take in consideration 2024. All right, court is calling 2024 CR 4389, State of Texas versus George Moncada. Could I have parties announced for the record for the state?
Jason.
Defense?
Basically.
Are you Mr. Moncada?
No.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there no applications? Mr. Moncada, did you review what's entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Moncada, did you review what is entitled Court Admonishments with your attorney? Did you understand it? Did you sign in all the appropriate places? Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently confident and was legally sane at the time of the offense?
My opinion is confident and was sane.
Mr. Moncada, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 14 months in the state jail facility. There are no applications. This will run concurrent with County Court Cause numbers 719-615, 719-616. State will take in consideration 2024 CR 4992. There's to be restitution, if any, to Maria Blankenbeck, Blankenbeck, Home Depot at 3111 Southeast Military Drive, San Antonio, Texas, 78223. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
No objections, Your Honor.
Did you review the document entitled Wavering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. After reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your
Anything you wish to say on behalf of your client?
Honor. I would just ask the court to follow the plea bargain that was negotiated between me and the state and my client's concurrence.
All right, the court will find you guilty. The court will sentence you to 14 months in the state jail facility. Give you credit for any time served. This will run concurrent with 719-615, 719-616. Take in consideration 2024 CR 4992. There's to be restitution, if any, to Maria Blankenbeck, Home Depot at 311 Southeast Military Drive, San Antonio, Texas 78223. Is there any thing else from either side with regards to sentencing? Did you review what's entitled trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. I understand that anytime you are locked up, that's a lot of time, even if it's for a couple of hours. So you have to ask yourself, what you stole from Home Depot, was it worth 14 months of your life? And then the poor lady who's out there and you're trying to do a maneuver that you've seen from the 80s shows, sliding across the hood of her vehicle and leaving a big scratch. She didn't come there for that. She was just there, you know. So you're gonna have to change. Otherwise, you're gonna find yourself living at the prison. You understand? All right, good luck to you, okay?
Thank
All right, court is calling 2024 CR 1908, State of Texas versus Miriam Padron Martinez. Could I have parties announced for the record for the state?
Jason.
Defense?
Carl Alexander.
And are you Ms. Patron?
Yes.
Counsel, have you received all the discovery?
To the best of my knowledge, Judge, the state has complied with 39.
And did you review it with your client?
I-
Court will find that the state is in compliance with discovery. There are no applications. All right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented? Any objection?
No, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of obstruction of a highway as a Class B misdemeanor?
Yes.
Range of punishment is up to $2,000 fine and up to 180 days in the Bexar County Jail. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her?
100%.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
All right, off the record. Excuse me, in the teal shirt? No, yes, you, yes. You're gonna chew your thumb off. All right, I'm just saying, this courthouse is not a clean place. There are germs everywhere. And just think about everywhere you touch with your hand and now you've put your thumb in your mouth and you're just going to town on your thumb. All right? All right, we're back on the record. Ms. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a United States citizen?
No.
Defense. Have you had a chance and opportunity to consult with your client about the immigration consequences of entering a plea bargain, in this case, and its impact on her immigration status?
Yes, Your Honor, and for purposes of the record, my client retained the services of Salman Haas, and former District Court Judge Aaron Haas is her immigration lawyer. He did furnish me with a very lengthy Padilla letter, which outlined what would be an acceptable outcome for our client, and this plea bargain fits within his guidance.
All right. Ms. Patron, did you have ample time to speak with an immigration attorney?
Yes.
And did you discuss with that attorney the impact the plea in this case will have on your immigration status?
Yes, Your Honor.
Did that include possible consequences such as deportation, the denial of naturalization, and the denial of re-entry into the United States?
Yes, sir.
All right. And do you understand the consequences of entering into a plea to the less included offense?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of obstruction of a highway, which is a Class B misdemeanor. They're asking that your punishment be assessed at 60 days in the Bexar County Jail. There are no applications, and there's 1 year driver's license suspension. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
Yes, Your
State is at the plea.
Yes.
And I will tell you, it states 1 year Texas driver's license suspension, but I'm doing a 1 year license suspension across the board. So that means Louisiana, New York, wherever it may be. You understand? All right. Did you review the waiver repeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions? Then to the lesser included offense of obstruction of a highway is a Class B misdemeanor. How do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Exhibit number one.
Honor. My client, Your Honor, with no objection.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have the right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
No, we're asking to reset this matter. She's a single mother. She needs to arrange for childcare while she serves her sentence.
All right, and how much time is she asking for that?
My son's birthday is on July 14th. I was.
Yeah.
And I don't know, I guess.
So what what affairs do you have to have in place?
I just have to make sure that he has, like, I know I have people who can watch him, but I have to make sure, like, arrange days and that with them.
So much time.
Okay, is 2 weeks enough?
It's 2 weeks, all right. So I will put you for sentencing on June 24th.
Need to wait for Norma to get a reset.
And that'll be at 9 a.m. Oh, no, I'll fill it out. I'm doing double and triple duty today. And then the last person we have is the defendant in the box. Is that correct, Deputy Laura?
I'm sorry? Yes.
He's the last one?
Yes.
Okay. All right, then we will be back tomorrow at 9 a.m. and we'll see how jury trial. All right, the court is calling 2024 CR 4664, State of Texas versus Robert Artegon. Could I have parties announced for the record for the state?
Alex Jackson,
Defense?
Megan Enriquez, present for John Kuntz for Robert Ortegon.
All right, are you Mr. Artegon?
Yes, sir.
Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name, please.
Robert Ortegon.
All right, so it's the court's understanding that previously a bond was set, is that correct?
Yes, and it's already been reduced once.
All right, and so the bond was reduced to $50,000, is that correct?
Correct, from 75 to 50.
All right, all right, State, have you had a chance to review the motion?
Yes, Your Honor.
Any objections?
I mean, just to the lowering, but I mean, just due to the nature of it, but other than that, we'll let them proceed and they do have a witness.
All right, you can call your witness.
Yes, Your Honor. We call Gabriela Ortegon.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Gabriela Ortegon?
All right, Mr. Ortegon, do you have any objections to this witness appearing by Zoom?
No.
State any objections?
No, Your Honor.
And defense, it's your witness, so I'm assuming you have no objection.
No objection.
All right, you may proceed.
Gabriela,
That's okay, I think she's still there.
can you hear me, Gabriela?
Okay. There, yes, sorry.
What is your relation to Robert Ortegon?
Oldest daughter.
Okay, and he was arrested on April 11th, 2024.
That is correct.
Okay, so he's been in Bear County Jail nearly 2 months, just short of 2
Correct.
months. And the complaining witness in this case is actually your daughter, correct?
That is correct, my oldest.
And it's from an allegation from 2 years ago?
Yes, September
Miss-
16th.
Despite your daughter being the complaining witness in this case, you are the one that is still making the efforts to try to get your dad out on bond, correct?
Yes, that is correct.
So let's tell the court about the efforts that you have made in attempting to get him out. And obviously, at the current amount, you still cannot get him out. How many bond companies have you called?
Yes, I've called a handful, maybe about 6 to 8. I tried the first time when the bond was set at the 75, and then when it got reduced again, I tried again. The amount is too high to take care of on my own.
And when you call these bond companies, do you discuss payment plans with them?
Yes, and also I know the co-signers as well, but that's been also difficult to kind of get also with coming up with the full amount that they're requiring.
And you have a sister, but she's in the Navy and she's currently on a ship in Japan, right?
Yes, that is correct.
So she can't contribute or help in any way financially at this time.
Right, and it's hard, very, very hard to get a hold of her.
At the time your dad was arrested, he was living in a senior living apartment complex near Woodlawn Lake, correct?
That is correct.
And since he's been incarcerated, his lease lapsed. Is that correct? And he lost his apartment.
Yes,
Did you and your husband have to go gather his belongings and move everything out and all that, arrange that?
yes, and I was actually just myself, just because it's just me and my girls. So that was also difficult to kind of take care of on my own, to move out all his stuff and take care of that on that end.
And if your dad were released, where would he go live since he lost his apartment?
Yes, he has his brother that lives by himself. He has a 2-bedroom home that he's willing to let him stay there with him, and it's just him.
Okay, so just to be clear, to make it clear to the court, he's not gonna go live with you and your daughters, correct?
That no.
Okay, and you know that there would be if you were released, there's a no contact order in place with your daughter, the one involved in this case, you know, right?
Correct.
And you know that you do think he'll abide by that no contact order?
Yes,
And there are no children in your uncle's household, correct?
no, correct. It's just him and my little dog that he's actually taking care of.
Your dog. Dog, you
Mhm.
said? Okay. And so one other big point that I want to make to the court is your dad's age and some of his health conditions. How old is your dad?
My dad, he is 76. He does have a pacemaker, a lot of heart condition, and right before he was arrested, he had a major knee surgery. And he actually did go back
Sorry, just one
to,
second.
Hold on.
She said, major knee surgery.
Okay, and
Yeah.
so after his knee replacement, which was about a month before he was arrested, he had some scheduled follow-up appointments that he hasn't been able to go to, correct?
correct, because he still has a screw in his knee that, or something that was left there that wasn't done properly that he needed to go take care of. But then that's when the arrest happened on the 11th.
And since he's been in custody, do you know that he was treated for a bladder infection as well?
Yes,
And he's in a wheelchair, obviously.
yes, and he does have COPD too, and just a lot of like breathing and just heart problems, and his health isn't at all good.
Is there anything else, Gabriella, that you would like Judge Boyd to consider before she makes her decision whether or not to reduce the bond any further?
Yes, actually Tuesday, my car was totaled. We were in an accident, me and my two girls. So I haven't worked since Tuesday actually, and I'm at home currently. So that's another thing that I kind of have to, take on my shoulders to, transportation of work, and then my time off of work, and my daughters too. And I was injured, and so was my 10-year-old.
Yes, and sorry, I forgot to mention your car accident. So in addition to sort of your own family situation, things you have going on in your life, and financial responsibilities with your children, how much money do you have raised and set aside currently for your dad's bond?
So far I have 1,000 to be able to, I guess I pay his bond.
And your dad
It's like
doesn't have like money in a savings account or in a bank account that you can access or anything like that, right?
No, he's always been on his Social Security check once a month, and that would take care of like the majority of his bills. So that's another thing too. I have to, keep track with that and make sure that that's taken care of.
Okay.
Like on
thank
top of
you.
mine.
The state might have,
Yes.
the prosecutor may have some questions for you, and the judge may as well.
Okay.
Just one, really. You said that he would be living with his brother. Has his brother or anybody else been reached out to see if they can help contribute to bond?
Yes, it's his brother, though. He's also in the same situation. He's single by himself on his Social Security check. So it's very difficult for him to contribute and help. Actually, I had to take couple of pieces of food for him also. That way he's okay himself. So he's barely able to, he can just take care of himself. And but as far as where he would stay, my dad would be able to stay with him because he's by himself.
And there's no other family members you can ask to see if they can contribute?
I've tried, but everyone, it's they're barely able to.
No further questions.
Okay.
All right.
No,
Any other
that's
witnesses?
everything.
All right, court will hear argument.
Judge, as is listed in our motion and the testimony that you've heard from Gabriella, we'd respectfully ask the court to reduce it further. We're asking that it be reduced from 50 to 25,000 due to his health, his age, his health condition, the fact that he needs to go to his follow-up appointments and things like that, that he would be living in a house with no children or anything like that. We'd respectfully ask the court to reduce it further.
State.
We've already agreed, Your Honor, to reduce it the first time. We had already reduced it by $25,000, which we feel was appropriate. So due to the nature of the allegations, we would just argue against lowering it any further.
All right, and what is his criminal history?
These are minor besides this.
And very old. I believe.
All right, and when we say minor and very old, what is it? Mr. Archigon,
Yes,
have you ever been arrested before?
no,
I
think
think
it's a
you
lot of
have been in
theft.
the eighties, but.
oh, that was way back.
No, I want you to listen to my questions.
Okay,
My question is, have you ever been arrested
yes,
before?
yes, yes.
For what?
It was so long ago.
Let me pull it up, Judge. I'm pulling it up.
I might have been for ticket violations or something like
I'm
that,
sorry, what?
for tickets.
It looks like, I mean, back in 1980, there was unauthorized use of a vehicle, then a bunch of traffic tickets, and a misdemeanor assault, an unlawful carrying of a weapon on a licensed premises, and then some, a DWI, and then some other alcohol related ones. And these were all before 1990.
Okay,
I'm asking. Okay,
all right. Any other argument?
My only other argument would be just be following up that, even since it's been, although it has been reduced and we were grateful for that, they still obviously haven't been able to make it at the reduced amount. That's why we followed a subsequent motion.
All right, well, as both parties are aware that when people are arrested and they have charges, everyone is innocent until proven guilty. The court's job in setting bond is to make sure that the community is protected and also make sure that it is the bond that will ensure a defendant's appearance. So this is what the court is going to do. The court is going to grant your motion. The court will set the bond at $30,000. There's to be partial GPS for medical appointments only. I'll ask that the GPS fees be waived. There's to be no contact with the complainant, and he's not allowed to reside in any residence that has minors. All right.
Thank you.
And then we'll be back on July 9th. Court is calling 2024 CR 2752, State of Texas versus Roberto Rosales. Could I have parties announced for the record for the state? Defense,
Pat Montgomery for the defendant.
are you Mr. Rosales?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did, Your Honor.
Are you the same Roberto Javier Rosales who was placed on deferred adjudication in 2024 CR 2752 for the offense of evading arrest detention with a vehicle on March 5th, 2024?
Yes, Your Honor.
All right, state.
Violated condition number one, on or about the 19th day of March 2024 in Bexar County, Texas. The defendant Roberto Javier Rosales committed the offense of criminal trespass in violation of condition number one.
How do you plead to that? True or not true?
It's true, Your Honor.
Your Honor, state will waive the other violation.
Any objection?
None, Your Honor.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor, I understand.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, ma'am, it's true.
Court will find violation of condition number one true. Is that proposed agreement?
Yes, Judge, it's to alter and amend to include IOP. Additionally, the defendant is going to go take a plea in this court on the criminal trespass case.
I thought it
Or criminal
was the
mission.
mischief case that you waived because there's restitution and you'll pay that restitution as part of that misdemeanor probation.
All right, probation.
Judge, what's listed on the court summary for probation is revocation. The justification is that he reoffended 2 weeks after being granted probation. Showing continual engagement in criminal activity while on probation. I would have to say that he did not report his initial office visit. He was granted probation 3/5/24 and picked up the new cases on 3/19/24.
Oh, is there something you wish to say?
I
Want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, I do.
All right, you can lower your hand, state your name for the record.
Roberto Javier Rosales Jr.
All right, so why are you charged with criminal trespass?
I
was looking to get some help from somebody I didn't know. I was being chased by some bad people.
No, get some help from someone where?
I was 2 blocks away from my house. And there were some people, it was over a game of pool, that were chasing me. And I wanted them to call the police. That's
So then where does and you didn't plead true to it, but my understanding so where does the criminal mischief come in?
as I
You're
was,
looking at me, but.
Oh, yes.
as I was knocking on the door, I opened the door. I was knocking on the door and I opened the door and I asked them to call the cops.
No, if you open a door, doesn't result in criminal mischief unless you damage it.
Oh, I damaged the door when I opened it.
There was
Yes,
a
ma'am.
window on the door that wound up, that was damaged, Your Honor.
Yes, ma'am.
The reason this was set for contested today was because he was able to articulate to me very viable defenses. He's chosen to forego that and enter pleas of true. He had the defense, in my opinion, perhaps of necessity. If he was in fear for his life and being chased by someone, he's seeking shelter, help, and someone to call the authorities. And of course, criminal mischief has to be committed intentionally or knowingly. It can't be done accidentally.
So here's my question.
Yes, ma'am.
Did you ever report to probation?
Yes, ma'am, I did. I went to that's why I didn't mean to interrupt, but I went to orientation and then the following on April 1st is when I was supposed to have my first meeting with my probation officer,
All
He
right,
was
so,
jailed.
but I was in jail.
all right, so here's the thing. I'm not doing this intensive supervision thing.
I understand.
So you have a choice. I can send you to prison for 3 years, or either you're still going into custody and you're doing the ISF.
May I have a recess to discuss what ISF means? Because I'm sure he doesn't.
Sure. All right, so we'll come back at 1:30. All right, Mr. Serrato, come down.
Met with Mr. Chiliez. He's putting together a Padilla letter. There is a paragraph that he needs to, in his words, wrap his head around to with respect to some potential future federal issues regarding the situation that he's going to get to me. As mentioned earlier, Your Honor, I've learned today that Mr. Serrato was indicted last week, right before they shut the entire system down. So I didn't get notice of that regarding a possession case. I haven't seen the labs yet. I believe the state has an issue as well moving forward today without the new #1 allegation of possession of controlled substance. I believe they have an issue with respect to their readiness, being able to move forward. We need to get people here with respect to that, as well as myself needing time to look at that as well.
All right, so this is what I don't understand, and perhaps everybody can help me understand this. This motion to revoke was filed February 2024. March, April, May, June. So help me understand.
Well, Judge, I haven't seen the lab yet because they hadn't been uploaded last time I checked all of the discovery. And he hadn't been indicted yet on it.
Okay,
That's one issue. The other issue was I did request the Padilla letter from the MAC on May 7th when this was set, because that was one of the issues that I learned in communicating with Mr. Serrato that he was not a citizen and he'd been previously deported. So that's my position.
and
If we
see,
were to
that's
move forward-
why when everybody came here in April, I said we would come back on June. So, and that was at the beginning of April. So you had a majority of April, all of May, and now we're in June. And nobody's ready. I don't understand. I don't understand the MAC not getting this information, the Padilla information. Aren't they supposed to do that?
Yes, Your Honor, they are.
All right, so I don't understand why it's a late date with that.
I don't speak for the MAC, Judge.
Okay. And what was his response as far as when is he gonna have the information that he's supposed to
He
have?
said if I need something today, and I would prefer to have an actual letter that I put in my file, Judge. I have the information from him that I've counseled Mr. Serrato about. So for those purposes, he will put together a letter and I can have it for my file, but I could move forward without the actual letter because I've counseled Mr. Serrato regarding, based on the information that I've gotten from the MAC regarding the Padilla issues.
All right, this is set for contested hearing on June 24th. I'm not giving any further resets.
Yes, Judge.
Okay, Judge.
All right, you have any questions?
No, ma'am.
All right, thank you. All right, so we are here. State, I don't know his age. Is this deaf, not deaf?
I have not taken this to this committee yet, Judge. I'll
Okay.
talk to my supervisor.
All right, so this is what we're gonna do. And I did have, Mr. DeLeon is appointed as a third chair for y'all. What we're going to do is I'm gonna reset this and I'm gonna reset it in 60 days. Is that enough time?
Yes, sir.
All right, so I'm gonna reset it in 60 days for the state to make a determination of whether or not they're seeking the death penalty. And also during that time, you all need to be working on discovery and towards getting all discovery.
Yes,
So
Judge.
is there any outstanding discovery or do we know yet?
I don't believe there is, Judge, but there may be a little bit associated with Mr. DeLeon's case, with the deadly weapon in the penal institution.
Yes.
He would, because I don't have access to that, he would have to tell us whether or not he's missing anything from that.
Okay. All right.
I'll probably, with the court's permission, get Norma to put me on that one as a second, just so that we have access to that discovery
Okay.
online whenever it comes back up.
All right. And state, you have a murder trial in August, right? All right. So what I'm gonna do is I'm gonna set this for discovery. And we'll set it for discovery. And also, I'm gonna give you all a little bit more time than the 60 days.
Okay, Judge.
Thank you, Judge.
So we'll set it towards the end of August.
Okay.
August 26th.
Okay.
So you all are gonna have to work off docket as far as discovery. And I know, state you turned over a hard drive.
Yes, correct.
Yes, Judge.
All right. Do you have any questions?
No, ma'am.
All right. So we'll bring you back on August 26th. And what's going to happen is the state is going to let the court know and let your counsel know whether or not they're seeking the death penalty. And also what will end up happening is we'll see where we are in discovery. And if there's some discovery missing, if y'all will be able to tell me that on August 26th.
Yes, ma'am.
All right. Is there anything else?
No, Judge, I don't believe so.
All right. Thank you.
Excuse?
Yes,
Thank
thank you. Good seeing you. Hello, Mr. Dotson. All right, today is your plea deadline date.
We rejected the plea. We have two cases on the docket and we would like our trial, our trials, or whatever you call it.
All right, Mr. Dotson. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, state. On Mr. Dotson, he wants his jury trial.
Yes.
So what's a good date?
Any date, Judge? It's a drug case, so I mean, it shouldn't be that long.
All right, and I'll need an acknowledgement of discovery in each case number. Ms. Ferguson, I need a jury trial date. It's a drug case. Should be short, 2 days.
There are two cases.
Yeah, 2 days. All right, so where are we on discovery?
I believe everything has been turned over.
I believe so, Judge.
All right, state, were you able to tender an offer today?
Yeah.
How old are you? All right, I'm gonna set this for a plea deadline date. Ms. Ferguson, can you put this on June 27th? All right, your plea deadline date is going to be June 27th. On that date, you need to let the court know whether or not you're accepting the state's offer. Do you understand? Right, thank you. Do you have questions about anything else? All right, thank you. Thank you. If you haven't come up, please. Hello, hi. All right, so the last time we were here, defense, it said that you were requesting some disclosures on something.
Yes, Your Honor, and those have been provided. At this point, defense needs to provide an external hard drive for a larger Coban. It is important because obviously it's the first take on the scene. So a regular 30 days, whatever Your Honor wants to give us, we have to bring them something to burn it on.
Okay, Norma, on Heda, Can you recall this for July 15th? All right, we'll be back on July 15th.
Thank you, Your Honor.
All right, do you have any questions about anything? All right, thank you.
Just wait for me.
And state, at that time, you'll need to be prepared to tender an offer. All right, pronounce your last name for me again. Gwali. See, he was wrong. He said Guli. Gwali. I'm gonna remember that. All right, who's the prosecutor on Stanley Gwali? All right, so where are we on discovery?
I think we're satisfied with that. The state has offered and we've accepted an offer for trial diversion. So we're submitting that right now. And then I assume we'll go through the normal process and be off your docket.
All right, Ms. Ferguson, I need a pretrial diversion date for Stanley Gwali. See if I say it several times, then I remember. All right, July 8th.
I think that's fine, Judge.
All right, once you sign the reset form, you're excused.
Thank you very much.
You're welcome. The court is calling 2024 CR 3681, State of Texas versus Justin Guzman. State, and are you Mr. Guzman?
Yes, ma'am, that's me.
All right, if you can raise your right hand for me, please. Do you solemnly swear affirm the testimony that you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Justin Guzman.
All right, Mr. Guzman, you had a previous attorney appointed to you. Did you ever have any contact with that attorney?
Negative, Your Honor.
All right, and did you request from the court to appoint a new attorney for you?
This morning, Your Honor, yes.
All right, so that attorney is Mr. DeLeon.
Yes, Your Honor.
All right, thank you.
Yes, ma'am.
We're back on the record in 2024 CR 2752. Are you waiving your right to appeal? All right. Then the court will grant the motion. The court will find you guilty. Court will sentence you to 3 years in the prison, give you credit for any time served. Else? And did you pay the $57 for drug testing?
I never got a chance to know that.
All right, so there's to be $57 restitution to DPS for drug testing. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
I'm going to request a therapeutic community for you. I don't have any control over them placing you in the program because I don't have any jurisdiction over them. However, just request it. It doesn't increase the length of time that you're in custody. You understand?
Yes, ma'am.
All right, good luck to you. When you are released, if you need something and I'm here, you can always come back to the court, okay?
God bless you. Thank you.
All right, thank you. Oh, God bless you too.